For today's U.S. Supreme Court case, we turn our attention to statements filed with the government relating to public companies. Public companies are required to file statements regarding their financial status and financial health, and these statements are, of course, part of the public record. These statements are at least used in part by people to make decisions as to whether or not to buy stocks in these companies. Of course, these statements that are on the public record must be true. And so the question is, well, if they're false, what is the remedy for a stockholder? What kind of things do a stockholder or some other person that has an interest in a company, what is their remedy and how do they go about showing their damages? So let's learn about this issue as it turns in the case of Slack Technology versus Pirani. Let's go ahead and get started with this. This case arises from public offering of a security, otherwise known as a stock, under the Securities Act of 1933. And the issue is what a public buyer must allege to state a claim. So in order to say I was hurt, what do you have to say happened? The relevant law requires a company to register its stock it intends to offer with the public with the Securities and Exchange Commission. You'd like to sell stock to the public, you have to register with the SEC. So if you have stock that you just trade privately, maybe not with the SEC. If you want to trade it publicly, the SEC would like to have a word with you. As part of the process, a company must prepare information that includes the information about the firm's business and financial health so that prospective buyers may assess whether to invest. So the public, they have to let people know what's going on with the company. The law imposes a strict liability on the companies with their statements with respect to material misstatements or misleading omissions. You can't lie to us. You can't hide the truth. You have to tell us what's going on with the company so people can be informed. In this particular case, Slack Technology, a technology company that offers a platform for instant messaging, conducted a direct listing to sell shares on the New York Stock Exchange. We'd like to sell our stock on the NYSE, please. Okay. As part of the process, Slack filed a statement for the shares it intended to offer in its listing. Under the process, holders of pre-existing unregistered shares were free to sell them to the public right away. So again, this is not exactly atypical, right? We're moving from a system where the shares are existing either between limited members of a company, so like a limited partnership or an LLC with multiple members, or some other arrangement where there is a relatively small number of members, small number of owners, and we're moving into a situation where those ownership shares are going to become public. So one of the things that you can do here in this particular situation, it says if you already own this stock in the company, one of the things you can do is you can list it for sale right away. So that's part of the deal. Under the process, holders of the pre-existing shares could sell them right away. The direct listing for purchase included 118 million shares that were registered and 160 million shares that were unregistered because of this change of status. We're moving from one kind of status to another, from less regulation to more regulation. So we have 118 million shares that are now registered, but we also have 165 million shares that pre-exist. So that's how we're dealing with that. Fine. Pirani, for his part, bought 30,000 shares on the date that Slack went public and later bought 220,000 additional shares. So he is buying some of these stocks. When the price dropped, Pirani filed a class action lawsuit against Slack alleging that Slack had violated the securities law by filing a materially misleading statement. So that statement that they filed as part of their ability to get onto the stock exchange was misleading. It contained falsehoods or it omitted things, and I paid a price based on the falsehoods. You tricked me. You've defrauded me. And so I'd like to sue you. Okay. Slack moved to dismiss, arguing that the complaint failed to state a claim because Pirani had not alleged that he purchased shares that were traceable to the misleading registration statement, leaving open the possibility he purchased shares not registered by means of this statement. So it only counts as fraud in the inducement if it induced me to the action, is the idea, right? These statements were misleading. The claim is, I bought the shares because you lied to me, right? Fraud in the inducement is basically what this boils down to. And Slack over here is like, but you haven't shown that you bought these shares because of the misleading statement. You might have bought the shares for other reasons, right? Did you even know the statement existed? Maybe you did, maybe you didn't, but can you prove that? What is the allegation here? The district court denied the motion to dismiss, but said, yes, you can appeal right away. The Ninth Circuit accepted the appeal and affirmed. So, no motion to dismiss. This case can go forward. Okay, so what is the right standard? What do you have to allege in your lawsuit? The Supreme Court holds the relevant law for the Securities Act requires a plaintiff to plead and prove that they purchase shares under the materially misleading statement. So if you want to argue fraud in the inducement, which is basically what this boils down to, I was tricked into buying the thing because of your misleading statement. You have to allege you did that, right? You have to allege it's because of the misleading statement. So if we want to break this down to a different example, right? A car dealership has an ad in a newspaper, and the ad is completely lying about this wonderful car they have for sale. All these wonderful things that are completely not true about the sale, right? You purchased the car. You claim you were tricked. Okay, but did you see the ad? Maybe you just drove by and just bought the car. So did the ad induce you? Can you prove it? You know, that you were induced by this as opposed to just walk by and be like, ooh, shiny, want. So if you want to say you were induced by the fraud, you have to, allege inducement by the fraud. That would be great. The relevant language authorizes an individual to sue for a misstatement or omission when the individual has acquired the security. The individual here, or Slack rather, argues the term, the security refers to security issued pursuant to the statement. So again, the nexus between the thing, right? It has to be tied, otherwise it doesn't count. Pirani says the term may encompass security not registered under the statement. So just any old stock will be fine. While the word such usually refers to a thing that's already been described, there's no clear reference describing what such security means. So they used a word that refers to an antecedent, but there's no antecedent. This is like saying the apple without describing what apple in advance. If I tell you I want a apple, any apple will be fine. If I say bring me the apple, and there's no understanding between us of what apple I'm talking about, that's a bit of a problem. But that's basically what Congress did here. Okay, this applies to such securities. Which ones? We didn't bother to tell you. I want the apple, but I'm not going to tell you which one. Hope you get it right. Lord, Congress sometimes. So as a result, the court has to figure out what the hell you meant by the apple or such security, because you didn't bother to tell us. What were you talking about? No one knows, but now we have to figure it out. Okay, so context might provide us some clues. First, the statute imposes liability for false statements or omissions in the registration statement. The statute uses a definite article to refer to a particular statement alleged to be misleading. And this way, it does seem to suggest the plaintiff must acquire the security under the document's terms. In other words, fraud in the inducement only counts if I was actually induced by the fraud. Otherwise, I wasn't induced by the fraud. In addition, the statute repeatedly uses the word such to narrow the law's focus. For example, referring to such part of the statement that contains a misleading statement, suggesting that when it comes to such security, the law speaks to security registration under the statement alleged to contain a falsehood. Only those stocks that were purchased based on the statement count. Section 6 of the statute indicates the registration statement is effective only for the security specified therein. The statement only applies to stocks offered as a result of that statement. Other statements might issue other stocks. Which one did you buy it under? Right? Again, if we want to go to like a car dealership example, now I'm a car dealer with 10 different ads. Some of them are extremely misleading. Some of them are extremely false. Some of them are true. All right, I went and bought one of the cars. Okay, which one did I buy? Under which statement, if any of them? Make the allegation that, you knew about it in advance. The damage caps in the statute also make less sense with Pirani's account of the statute. Collectively, the contextual clues persuade the court that Slack's reading is better. While direct listings like this are new, so this particular aspect of securities law is relatively new in this particular aspect, but okay. The court's conclusion is not. The majority of courts for years have held liability extends only to shares that are traceable. So again, fraud in the inducement only applies if you were induced by the fraud. Resisting the conclusion, Pirani argues the court should read the phrase such security to include not only the securities registered under the defective registration statement, so not only those shares that said, we are currently offering 10,000 shares, here's the description of the 10,000 shares. So should we read this statement only applying to the 10,000 shares? Pirani says no. Other shares should be read into it too. Okay. But also shares that would have some sort of relationship of some variety, whatever that would be. Pirani contends that but for the existence of the registration statement with respect to those shares, the unregistered shares would not have been eligible for sale to the public. So he said, if you didn't lie about those shares, these other shares, you couldn't have sold. You had to lie about those shares in order to offer these shares because of the nature of the law, right? But you only lied about these shares. You didn't lie about the other shares. Pirani does not explain what the limits of the rule would be, which is always a bad place to start, how the court might derive this from the relevant statute, or how any of it can be squared with various contextual clues, which suggest liability runs with only those shares that the ad talked about. For sale, 1 car. Other cars as well. For sale, 10 cars. Other cars as well. No. For sale, 100 cars. Other cars as well. No. Just the ones that were described by the ad. Okay. Otherwise, what were we talking about? Right? If I lied about if I lied about the car or 10 cars or 100 cars, what does that have to do with the price of tea in China? Pirani argues if Congress wanted to have liability to attach only to the securities that, the statement talks about, it could have borrowed language from a different part of the statute. So Congress could have been clearer, which, even the Supreme Court agrees with that much. On its own term, the argument also shows that Congress could have written the statute more clearly that liability attaches to any security or any security bearing some relationship. So yes, Congress could have been clearer in limiting liability. Congress could have also been clearer in expanding liability. Congress was a little unclear. So yes, they could have been clear the one way. They could have also been clear the other way. Things are a little ambiguous. We have to figure this out now. Finally, Pirani argues that adopting the broader reading will expand liability for falsehoods and omissions and better accomplish the purposes of the act. If it extended to all shares everywhere, then that would help companies be more responsible for lying. The court cannot endorse this purpose, nor is Pirani's account of the law's purpose altogether obvious. An alternate inference in the opposite direction is at least equally plausible. So yeah, maybe Congress wanted this to apply to all shares everywhere because that would expose liability, but maybe Congress didn't want that. Maybe Congress wanted it to only be about the things that were mentioned in the ad. So maybe they wanted it to be, if you lied about one car, your entire dealership sucks. But maybe they wanted it to only be about the thing that was mentioned in the ad, so that only those people that are harmed by the ad can sue for the ad. This applies in your local newspaper with your local Chevy dealer. This applies in the SEC. It's basically fundamentally the same. The court concludes the better reading requires the plaintiff to prove and plead that they purchased the shares because they were actually induced by the actual statements relating to these actual shares. Gorsuch delivering for a unanimous Supreme Court. Thus, that brings us to the end of the case dealing with Slack versus Pirani. Pirani bought some shares of Slack. He is sad the price went down. He believes that Slack made misleading statements or false statements in its registration with the SEC. He said, "Hey, you said you were a healthy business, and you're not a healthy business. You lied to me, and I paid too much." Well, Pirani over here has a problem because he can't prove the shares. He didn't even argue the shares that he bought were based on that particular statement. The statement says, now for sale. These 100 million shares, come buy them now. Did you buy those shares? Or did you buy different shares? Did you buy it because you were induced? Were you defrauded? Or are you just sad about the price going down? So Pirani over here has to say, yes, I relied on the statement. Those shares came from that, and he can prove that. presumably through a temporal connection, for example, based on timing would might maybe be a clue. But he has to actually do that. He can't just say, you lied about some shares and something, something, something else, magic underpants. So he has to actually show fraud that actually induced him. And that brings us to the end of discussion of this story.